Good evening, ladies and gentlemen. Good evening and welcome to tonight's inaugural lecture by Tsachi Keren-Paz. I'm delighted to see you here this evening, delighted to welcome Tsachi's colleagues, professional colleagues within the school, across the university, and family members as well. It's good to see you here this evening. Obviously, the purpose of an inaugural lecture is to enable the new professor to demonstrate their expertise and their particular ideas and thoughts in their specialist field. But it's also an opportunity for us to present to a wider audience some understanding of the key research which is going on at Keele and some of the developments and ideas which are emerging from our academic colleagues here. Tsachi has had a very distinguished career. He graduated from Tel Aviv University, the University of Toronto, and from Osgoode Hall Law School at York University, and has had an academic career across 3 continents, both in Israel and in Canada, and then, of course, here at Keele. And Tsachi came to Keele Law School in August 2007, and then has been promoted and was awarded a chair as a professor of private law in 2013. Tsachi's research expertise is focused particularly on tort law, private law theory, egalitarianism in private law, and a whole set of themes around medical negligence and private law. And his current research interest lies with the effect of tort law on medical innovation, the relationship between tort law and restitution, and the dividing line between restitution for wrongs and restitution by subtraction, the relationship between gain and loss-based remedies. In tonight's lecture, Tsachi is going to defend an alternative view according to which private law and law generally is one social tool to achieve different forms of justice. While not denying the importance of corrective justice to private law, such an account stresses the importance of distributive justice, and in particular of equality and fairness, and the ways in which distributive justice informs the scope of obligations recognised by corrective justice. This approach will be demonstrated by focusing on several examples, including the call for a wealth-sensitive standard of care in the tort of negligence, and explaining the regressive effects following from the rule of full compensation for personal injuries, and examining the scope of obligations towards victims of sex trafficking by traffickers, clients and the states. So can I warmly welcome Tsachi Keren-Paz, Professor of Private Law, and invite him to present his inaugural lecture, Private Law, a Social Tool that Reflects Different Forms of Justice. Tsachi.
Thank you, the Vice-Chancellor, for this generous introduction, and thank you all for coming to this event. Among the audience, I'm delighted to see here there are some who came out of town for this evening's lecture, including some ex-Keeleys. I'm too afraid to forget anyone, or even worse, to thank last-minute dropouts, so I won't use names. But thank you for making the effort to come. It means a lot to me. But I think that the winner for coming from afar to this event is my mother, Dvorah, who came especially from Israel for this lecture. So many thanks for this. And thank you so much for all the love, support, and help that you've been giving me for all these years. I owe you and Dad, who passed away 11 years ago, many debts, financial, intellectual, educational, and emotional. So thank you for all of them. Toda Ima. Now, when I'm in the business of thanking the women I love most, I'd like to thank my better half, Marie, who manages to be at the same time my #1 fan and my fiercest critique. So thank you for being both, and thanks for being such a fantastic partner, colleague, and an inspiration, and for all the support you give me and the happiness you bring into my life. Many thanks to all my law school colleagues, past and present, for your friendship, collegiality, and intellectual stimulation. And many thanks to the support staff for all the admin support that you've been giving me. All of you really make Keele a second home. Special thanks to Sarah Lane for helping organizing this event, and to Marie, once again, for helping me preparing for this talk. All remaining errors are definitely hers. Finally, lots of love to my daughters, Daphne and Danielle, who are still too young to be here tonight, but I look forward to seeing them in the reception after this talk. So as the Vice Chancellor mentioned, the title of my lecture is Private Law, a Social Tool that Reflects Different Forms of Justice. And I will try to capture in it insights from the two main projects I was working on in the last decade or so. I will start by explaining what private law is. So it is the area of law governing interactions between individuals, quo individuals. So you're all familiar with contract law as one major area of private law. And the basis for an obligation under contract law is the parties' agreement. My main research area, and the one I will discuss this evening, is tort law, which is the area of private wrongs. It deals with the non-consensual interactions under which one party causes harm to the other party or infringes his or her rights. Examples include road accidents, medical negligence, and the law of defamation. There are many other areas in private law, such as property law and restitution law, which is the area of law governing restitution of profits made at the claimant's expense without a good reason. In terms of terminology, the relevant parties to the private law interaction are the claimant and the defendant. In tort law, the claimant is the victim and the defendant is the tortfeasor. I would like to turn now to the debate about the proper role of private law. The question essentially is what should courts and legislatures take into account in deciding legal rules. Tort law, and more generally private law, reflects one or more of the following forms of justice. Corrective justice, which is linked with a formalist approach to law. Economic analysis of law, which reduces justice to a commitment to achieve efficient results. And distributive justice. As we will see, a commitment to just distribution can mean different things to different people. The emphasis in my work has been the promotion of equality in tort law and the argument that tort law should not be understood to reflect only corrective justice or to promote only efficiency. As I will attempt to show, tort law is inherently regressive, meaning that it works consistently against the disadvantaged. Now, the fact it is regressive is not a problem according to corrective justice supporters and efficiency supporters, although for different reasons. So in this talk, I will try to explain why tort law is regressive, why we should care about it, and how we can imagine a more egalitarian tort law. While perhaps the most dominant theoretical approach to private law is corrective justice. Corrective justice is based on an interaction between the claimant and the defendant and has three elements. The claimant has a protected interest. The defendant has infringed that interest without justification. Therefore, the defendant is under a special duty that no one else has to repair the infringement and its consequences. There are several ramifications to understanding private law as based only on corrective justice. Corrective justice focuses on a backward and individual look. It looks only at the interaction that happened. This means that it ignores future consequences and distributive considerations. Corrective justice can loosely be tied with a formalist approach that courts only apply rules, they don't create them, and that the decisions are value-free, technical, and apolitical. Another dominant approach, mainly in the US, is efficiency or economic analysis of law. According to such an approach, legal rules should maximize wealth. We should choose the rule that brings about the biggest pie, and again, the distributive consequences of the rules should be ignored. A rule that brings about a world with 100 pounds in aggregate is by definition better than a rule leading to a world with 99 pounds, whatever the distribution is. In the area of tort law, wealth maximization is translated mainly to the decree of decreasing the sum of the cost of accidents and the costs of their prevention. And part of this logic calls for risking those who already have less, since they have less to lose. So if we look at the work of the high priest of economic analysis of law, Professor and Judge Richard Posner, we could find the following acknowledgement about the ways efficiency works in tort law. A person should feel free to drive faster in a poor than in a wealthy neighborhood because expected accident costs are on average lower in the former, making the optimal expenditure of time and other resources on avoiding accidents in the poor neighborhood also lower. So basically, because it is cheaper to injure the poor, we should take less care not to injure them. This is what Posner says. So, how do I feel about Posner's view? In fact, I take issue with both corrective justice and efficiency enthusiasts, and I think that they are both wrong for ignoring the distributive consequences of private law rules. My approach to tort law is rooted in a legal realist and pluralist tradition, viewing law as in an instrumental and functional way, and in a branch within this tradition which is concerned with decreasing power gaps between the haves and the disadvantaged. And I will try and summarize my approach to tort law in the following 4 points. First, law is a social tool, so its consequences should not be ignored. The idea is that private law and law in general is created by society to further social goals, so it needs to be understood functionally. Private law does not have inner logic that we are bound to follow or respect, a logic that precludes us from taking distributive considerations into account. If needs be, we should prefer just results over commitment to coherence. A pure conceptual approach to law, devoid from reference to external empirical facts and values, is no more than transcendental nonsense, as Felix Frankfurter has coined the conceptual approach in his classic 1935 article. The second point is that specifically the distributive results of private law rules should be taken into account. And this is still quite controversial, as we could see from the following quotes by Duncan Kennedy, a professor of jurisprudence at Harvard University. Peace and happiness seem to require that most of the time we do not think at all about the justice of distributive shares. Law students blush if asked to discuss these matters in the publicity of the classroom. And his second quote, the question of distributive justice, of equality across class and race and gender lines, is the unacknowledged elephant in the rooms where private law is discussed. This is part of his blurb to my 2007 book. So in this book, Torts, Egalitarianism, and Distributive Justice, I have addressed 4 major arguments against an attempt to redistribute through private law rules, and found them ultimately unconvincing as far as they support a blanket refusal to take distributive considerations into account. The first misconceived argument is that judges are unaccountable and redistribution is political, therefore private law redistribution is illegitimate. It is true that judges are unaccountable, but distribution is inevitable. Since any rule has inevitable distributive results, these should be taken into account. More crucially, a decision to keep the status quo is as political as a decision to change it. So judges' unaccountability cannot serve as an excuse to avoid taking the distributive consequences into account. The second argument is that the distribution is random and partial. There will be a gap between society's ideal distributive scheme and what can be achieved by any tort or private law rule, and only some of those we would like to, ideally to participate in the distribution, would do so. This is undoubtedly true, but as long as the redistributive rule brings us closer to the ideal distributive result, it is better than nothing. Redistributive rule could be either anti-haves, concerned that the rich have too much, or pro-disadvantaged, that the poor don't have enough. A redistributive rule that aims to be pro-disadvantaged rather than anti-haves would necessarily bring both interacting parties closer to the ideal distributive scheme in comparison to the status quo, since what is taken from the few rich should be given to the numerous poor. Moreover, the more redistributive private law rules are created, the more inclusive the redistribution will become, so it will be less partial and less random. Participation in the redistribution will also broaden through insurance pools. The third argument is that distribution through private law rules is ineffective. But this would depend on the circumstances and on what is being distributed. As I will show in my case studies later on, we could identify instances in which distribution through private law will be effective and at times even more effective than distribution through the tax and transfer system. The last argument is that private law distribution costs us too much in terms of achieving other goals. For example, efficiency. But this as well would depend on the context. At times, the more egalitarian rule will be also the more efficient. At other times, the efficiency loss would be justified since private law redistribution is the most effective way to redistribute. The third point in my approach to private law is that private law reflects different forms of justice, corrective, but also distributive. So I would not like you to leave this lecture thinking that I think that corrective justice has no role in tort law. Far from it. Corrective justice is still the most important form of justice in private law, but it is not the whole story, nor should be. And the last point is that distributive considerations help decide whether there is a duty of repair as a matter of corrective justice. Distributive and corrective justice are not separate forms of justice competing for control in the private law arena. Rather, distributive justice helps us understand what the proper requirements of corrective justice are. Without a proper understanding, without a proper distributive justice background, corrective justice is quite hollow. So what do I mean by distributive considerations? Depending on the context and area of law, there could be different distributive considerations. We might want to distribute according to merit, desert, equality, fairness, according to a loss spreading policy, or preference of the cautious over the careless. In tort law, I would like to highlight equality and fairness. By equality, I mean the criterion that legal rules should decrease, or at least not increase, gaps in society. It is important to see that there are two versions here. The broad version is that we could use private law rules to decrease gaps in society whose causes are external to the rules themselves. The narrow version is that legal rules should not themselves increase the gaps between the disadvantaged and the haves. Fairness stands for the idea that those who benefit from an activity should bear its costs. And as we shall see later on, fairness could support liability without fault based on the fact that those liable are the ones benefiting from the risk-creating activity. So here are 4 case studies from my work on the relevance of distributive considerations to corrective justice and on understanding law as a social tool. The first example is where to build a refinery which might explode and expose the owner, if negligent, to liability for the damage caused. The second example is whether to invest in a security device in a car which might reduce property damage to other cars. The first 2 examples deal with the question how courts determine whether the defendant was negligent and therefore liable to the damage caused. In tort law's terminology, it is a question about the standard of care. As I will explain, this determination is made by comparing the costs of the accident and the cost of precaution, of preventing the accident. In the first example, the problem is that the traditional rule overly risks poor victims. In the second example, the problem is that the traditional rule might overly burden poor defendants. Both examples, therefore, raise the question whether we should adopt a wealth-sensitive standard of care. The third example is about twins, a boy and a girl, injured in a road accident. It shows how the basic tort remedy, the principle of full compensation, leads, among other things, to gender injustice. While in the first two examples, the regressive effect of tort law derived from standard of care determinations, in the third example, the regressive result is a consequence of the rule governing the remedy, the way we award damages. In the fourth example, a client buys sex from a victim of sex trafficking without knowing that the claimant is forced into prostitution. Here the questions are whether there should be strict liability, liability without establishing the defendant's fault, and if so, through what torts? As we shall see, this example as well raises issue of gender justice. So starting with the first example of poor town and rich town. Let's say JR has to decide where to build a refinery. The choices are poor town and rich town. A given safety device would decrease the risk of an explosion costing life and property. In standard of care determinations, we compare the expected costs of the accident, which is the size of the damage if the accident happens, multiplied by the chance it would happen, with the cost of precaution. So I need to spend 100 in order to prevent an expected accident cost of 200. If not, I'm negligent and will have to pay for the actual damage I caused. But I don't need to spend 200 to prevent an accident whose expected cost is 100. So then, I wouldn't spend in precaution, and the victim is left with the damage without being compensated. So in our example, let's say that the cost of preventing a 10% chance of explosion is £800,000, and that this is constant, the same in both poor town and rich town. If there will be an explosion in rich town, the overall damage will be 10 million. So then the expected cost is 1/10 of it, 1 million. If there will be an explosion in poor town, the damage will be only 7 million. And again, the expected cost of 0.7 million, 1/10. The crucial point is that the difference in the expected cost is due to both the value of the property and future lost earnings, which are both higher in rich town. According to the traditional rule, it is only negligent to fail to prevent harm in rich town. You need to spend 800,000 in precaution to prevent an expected accident cost of 1 million, the higher amount. You do not need to spend 800,000 in order to prevent the lower cost of 700,000. The result would be that the refinery would be built in poor town without investing in precaution. And if there is an explosion, the residents would not get compensated. This is an example of how tort law can cause the poor to be even poorer. Note also that even if there would not be an explosion, the residents of poor town are worse off, since the prospect of being injured without being compensated would affect the value of the property and the cost of the premiums for life insurance the residents will need to pay. So what are the possible solutions to this problem? One solution would calculate the expected accident cost for purposes of determining negligence based on the average value of both poor town and rich town residents, whether the explosion happens in rich town or in poor town. But if according to this calculation the defendant is negligent, he would pay the actual loss he caused, not the average, but the actual. So in our example, the average of expected accident cost of 1 million in rich town and 0.7 million in poor town is 0.85. Since precaution cost 800,000 are lower than accident cost 850,000, it would be negligent not to incur cost of precaution even in poor town. So JR will build a refinery in poor town. will still prefer not to invest in precaution since the 800,000 are higher than the 700,000 expected accident cost he is likely to pay. But if the accident will happen, at least he will need to compensate the residents of Poor Town. A more radical solution would be to take into account diminishing marginal utility of money to conclude that only exposing the residents of Poor Town to the risk of explosion is negligent. Since losing your first pounds creates more disutility than losing your last pounds, we might conclude that risking the poor is negligent, but risking the rich is not. This would reverse the traditional rule under which it might be negligent only to risk the rich, but not to risk the poor. Under such a rule, the refinery might be built this time in Reachdown, since only in Reachdown JR is not exposed to the risk of paying compensation in case an explosion occurs. If, however, for reasons external to tort law's incentives, the refinery is built in Poor Town, JR will still not invest in precaution as long as his expected liability is based on the loss actually caused, 700,000, which is lower than the cost of precaution, 800,000, but at least he will pay for the damage he caused. So I move to the second example of installing a special security device in a car. Remember that according to the traditional analysis, I need to spend 100 to prevent a loss of 200, but do not need to invest 200 in order to prevent a loss of 100. But what if the 100 is out of 1,000, which is all what the defendant has, and 200 is out of 200,000 that the claimant has? Am I expected to invest 10% of my wealth in order to prevent a loss of 0.1% of the claimant's wealth just because it is efficient? And if we reverse the figures, is it acceptable that the defendant would not be required to spend 200 out of the 100,000 he has to prevent a loss of 100 out of 1,000 to the claimant? I argue that since determinations about negligence are about the proper balancing of burden to yourself and risk to others, it would be unethical to ignore existing wealth which affects the effective burden from bearing either precaution costs or accident costs. If we take this normative commitment to a concrete example, it would not be right to expect those whose car was 1,000 pounds and those whose car was 50,000 to invest the same in precaution to prevent property damage to cars, especially when we recall that the average value of cars, which affects the value of the accident costs, depends on the claimant's, meaning the owner's, means. It would only be just, therefore, that the burden from bearing cost of precaution would be also wealth sensitive. I therefore suggested the same status victim rule, which could produce differentiated burdens. For calculating the accident costs, we will assume that the average value of the cars of all other road users is the same as the value of the defendants. This will produce a progressive standard of care a bit similar to progressive taxation. Those with more expensive cars will need to spend more in precaution than those with less expensive cars. To see this, have a look at the table. Let's assume that the average value of all cars in the market is 5,000, and that the device decreases by 1% the chance of an accident causing total loss to the victim's car. According to the traditional rule, the owners of both cars worth 1,000 and 50,000 would need to spend the same in precaution, since precaution costs, which are 30 in my example, are lower than accident costs, which are 50. They are 50 because it's 1% of the average value of all cars in the market, which is 5,000. According to the same status victim rule, the adjusted accident costs are based on the value of the defendant's car. Those whose car worth 1,000 would need to invest in precaution up to 10 pounds, 1% of the value of their car. Those whose car worth 50,000 would have to spend up to 500 in precaution. So the owner of the cheap car would not need to install the device whose cost is 30, but the owner of the car was 50,000 would. There are some theoretical ramifications to the examples I have just discussed. First, it reveals how distributive justice affects corrective justice. The poverty is not an excuse. So we don't say the defendant is negligent but poor, so does not pay. Rather, we view his poverty as justification not to spend in precaution. The defendant is not negligent, since we ought not expect from him the same standard we would expect from someone with better means. Therefore, there is no corrective justice duty to repair the loss. The difference between negligent but poor and not negligent given limited resources explains why a redistributive legal rule is more effective than redistribution through the tax system. A rule ignoring the defendant's lack of means, accompanied by a transfer payment to the poor but negligent defendant, still undeservedly stigmatizes the defendant as negligent if he failed to invest in precaution. The transfer through the tax and transfer system might be stigmatizing as well, as part of the undeserving poor discourse. And it is not even clear that the administrative costs of such a system are lower than those involved in adopting a wealth-sensitive standard of care. I move to the last theoretical lesson. In the first example, Putin and Reachdown, the issue was of coming up with a rule that would prevent over-risking vulnerable victims. Here, the concern is with preventing excessive burden on vulnerable defendants. So egalitarian sensitivity cannot be translated into general rules of more or less liability. This depends on comparing typical litigants. This might look trivial, but there seems to be a bent in the progressive tort literature in the direction of more liability towards the disadvantaged. But the flip side is the need to examine that there are no excessive liabilities on the disadvantaged. The third application is about the principle of full compensation. In tort law, you receive what you lost, no more, no less, which depends on what you had. We already saw in the Putin example and in Posner's quote how this might lead to excessively risking the poor. Remember, as I teach my first-year students, that tort law gives an incentive if you must choose not to run over the 30-year-old barrister, but rather to steer away and run over his 80-year-old grandmother. Consider now a serious road accident in which 4-year-old twins, a boy and a girl, are seriously injured. According to the traditional rule, the brother will receive higher damages since men earn more than women. And in the absence of established individual pattern of earning history indicative of individual earning capacity, the court will project into the future by using statistics. An egalitarian rule would give the brother and the sister award based on the same earning capacity. And this could be done in one of two ways. Either a combined men-women earning index to both, so we would resort to the average general income, which includes the income of both men and women, and we'll give it both to the boy and the girl, or we'll take men's average income and we'll give it to both siblings. It is important to see that if you opt for the combined average, the first solution, the defendant, which in reality is the insurance company, does not pay more. Instead of paying 100 to the boy and 60 to the girl, he would pay 80 to each. And this could be generalized for the more common case in which only one child is injured. Over time, what is paid more to the girls is offset by paying less to the boys. The issue, therefore, is one of what I term intra-group justice. Injured boys subsidize injured girls. The injured boy will receive less than what he would have received statistically if not injured, and the girl would receive more. But boys and men do not have a protected interest in benefiting from patriarchy. So tort law ought not replicate existing inequalities in the paid and non-paid labor markets by projecting them into the future and using them as a reason to give lower compensation to the girl. We seem to have here a tension between the demands of corrective justice and distributive justice. Corrective justice would demand that the broader structural considerations about social and gender injustice would be ignored, and that both the boy and the girl would receive what they would have likely received had the injury not happened. Distributive justice would lead us to resist such a remedy in order to prevent the injustice of undercompensating the girl who suffered the same injury of her brother, the same injury as her brother, just because of her sex. In Migdal and Abu Hana, the Israeli Supreme Court applied this distributive sensitivity to a claim by an Arab girl. That case raised also issues of ethnic injustice in addition to gender injustice. The insurance argued that Arab women from the girl's village do not tend to work out of home, so there is almost no loss of future income. The court ordered a general men-women index for compensation, which also ignores ethnic-based differences in earning capacity. If this analysis is correct, it raises the question whether a much more radical reform in compensation is justified to move away from individual compensation to uniform compensation. If it is true that a 4-year-old boy does not have a protected interest in benefiting from patriarchal structures in a case of an injury, why should he benefit from the same structures if injured as an adult after these patriarchal structures have operated? Perhaps then, tort law should give a uniform compensation and send privileged individuals to cover their additional loss through first-party insurance. I turn now to the fourth and last case study taken from my recent research about private law responses to sex trafficking. My general claim is that private law causes of action should be part of the response to trafficking. So potential claims could be against traffickers for both the harm they caused victims and the profit they made at their expense. The crucial point here is that these sums should accumulate rather than requiring the victim to elect the higher between the loss and the gain. Against the state for what it confiscated from traffickers, since it is in fact victims' money. So while the state intends to confiscate the trafficker's gains, it in fact takes money that the victim produced and that belongs to her. Against clients for buying sex from a forced commercial sex provider, a term I prefer over prostitute, prostituted woman, or sex worker, such liability should be strict. And against clients for contributing to the victim's trafficking by posing demand in the market. Such liability should be fault-based. The intuition is that without demand for commercial sex, women would not be trafficked in order to partially meet this demand. Liability under this theory is not based on direct contact with the victim. So a client who bought sex from non-victims in Stoke would still be liable to victims in Stoke, since his consumption contributed to the fact that they were trafficked into Stoke. I would like to focus on the third claim, which is based on the direct sexual contact between the client and the victim. Think of a client who buys sex from a commercial sex provider without knowing she is a victim of trafficking. One might argue that if the proportion of victims to non-victims is sufficiently high, and if commercial sex providers who are not forced are still overwhelmingly exploited, the purchase of sex was faulty, so should lead to liability under negligence. Indeed, this is the gist of the argument about liability for contributing to the creation of demand. But even if we assume what I call the rosy, pinky picture of the sex industry, according to which the number of victims is very low and most other commercial sex providers are happy and not exploited, and therefore the client is not at fault in buying sex in this market, still it would be just that the client would compensate the victim of trafficking based on fairness and equality. In terms of fairness, clients benefit from buying sex in the market, and victims are harmed from this activity. No one could deny that the harm victims suffer is very significant, since this harm is the result of an activity that the client pursues for his own benefit, sexual gratification, and this harm is borne by the victim. It would be fair that the client would compensate those who have to suffer in order for a thriving sex market to exist, even under current assumption that the market is unproblematic. The second justification for strict liability is equality, and there are two dimensions here. Socioeconomic. Research about clients suggests they are heterogeneous and come from all ranks of society, rich, poor, and average. Victims of trafficking, on the other hand, are overwhelmingly poor or very poor. Strict liability would transfer money from the average to the poor and is therefore progressive. In terms of gender lines, clients are overwhelmingly men, victims overwhelmingly women. So strict liability would transfer money from men to women and would bring about a more egalitarian result in terms of gender justice. The most straightforward way to impose strict liability is in the form of battery, which is a tort that protects bodily integrity. But I would like to introduce here a more radical and controversial claim that the client should be liable for conversion, which is a tort protecting the owner of property from significant interferences with her dominion over the property. So if I go to the pub and someone takes by mistake my coat because he has an identical coat, he has converted my coat and is liable to me, even though his mistake was reasonable. The argument is based on a fact and on a normative commitment. The fact is that victims of sex trafficking were rendered into chattel, and research I cite in my book found very interesting and troubling indications that victims are treated like chattels by both traffickers and clients. Many were sold from one trafficker to another. 2 victims were sold for cash and a Fiat Punto car. 1 victim was rented by one trafficker from another. 2 victims reported they were inherited by family members of the trafficker who passed away, and others reported that they were used as collateral. Yet others report that they were stolen rather than abducted from one trafficker by another. The last example shows how victims internalized their objectification. Despite the fact that in the language, in this case Romanian, there is a word for being abducted, they reported after the exploitation was over that they were stolen by another trafficker. Research about clients found that for clients, women's bodies and sexual services are regarded as commodities that are purchased in a similar fashion to other goods. With enough money, you can buy whoever, whatever you want. The normative commitment is that human beings should not be owned by anyone, and in this sense have a right of self-ownership. Accordingly, victims are treated as both subject with the right not to be owned and object. As subjects, they sue clients for the harm in being treated as property by the clients. At first glance, this is problematic because it seems that courts give their approval to the objectification of women. In fact, there is no strong reason to oppose the suggestion on symbolic grounds. For one thing, each victim is left with a choice whether to use this cause of action, indeed whether to sue at all. And if she feels that the symbolic or practical benefits from doing so outweigh the costs, who are we to second guess it? Moreover, once it is understood that this cause of action is a legal maneuver by the claimant to get better vindication of her rights, recognizing this cause of action by courts in fact sends a desirable symbolic message of respecting the victim's account of her experience. Victims are not treated only as objects, since they, and they alone, can sue under this cause of action. Obviously, one trafficker cannot sue another in conversion for abducting the claimant. Furthermore, especially since the label of conversion is so shocking, it might force us to better appreciate the unique and horrific experience of sexual slavery. Finally, it is not that recognizing this cause of action objectifies victims. The horrible reality did. This cause of action only gives interested victims another and potentially a better remedy against clients who violated their rights. Now, this relates to a broader advantage of private law as a response to sex trafficking. Some sex work advocates warn against a rescue industry which forces the status of a victim on sex worker migrants. Even if true in the criminal context, a private law response is immune to such a critique, and it allows each commercial sex provider the freedom whether to conceive of herself as a victim, and if so, whom to sue, and under what cause of action. The following are the main two theoretical ramifications from this example. First is that, once again, distributive considerations, in this case fairness and equality, are relevant in deciding the appropriate scope of liability and the content of corrective justice. Such considerations support strict liability of clients to victims as a matter of corrective justice. Similarly, we need to resort to value judgments, including about social justice and gender justice, to decide whether the risk in buying sex in the relevant market is reasonable or not. Like the previous examples, distributive considerations help us decide whether the client's activity should be considered as negligent and therefore triggering corrective justice duty to repair under the tort of negligence. The second lesson is about understanding law as a social tool and rejecting formalism and a conceptualist approach. Victims could ask to be juridically classified as property if this is useful or desirable to them. Concepts are helpful as analytical tools which help to explain why certain policy considerations are relevant or not in a certain context. Affording victims property-based remedies is conceptually justified since it corresponds to an essential aspect of the violation of their rights, their treatment as property. No conceptual transgression occurs by affording victims the benefits of property law to remedy the violation involved in treating them as property. Indeed, the solution I support serves poetic justice, since the ultimate response to the objectification of victims by clients should be to afford the victim a proprietary-based claim against the client. Clients who treat victims as property are met with the onerous burdens imposed by the common law on those who seriously interfere with the owner's dominion over his property, over her property. Legal rules are a human creation whose aim is to promote human flourishing and justice. Concepts are meant to serve jurists, not to control them. Lord Atkin famously said in United Australia and Barclays Bank about the forms of action, when these ghosts of the past stand in the path of justice, clanking their medieval chains, the proper course for the judge is to pass through them undeterred. It would be most unfortunate if in the 21st century the clanking chains of concepts replace those of the forms of action in the path of justice. I hope that by now I have convinced you that the following 4 propositions are correct. Private law affects people's life and has distributive consequences. So it would be immoral to ignore these consequences when we decide what the law should be. Private law has no immanent structure or logic which should constrain the considerations we ought to take into account, such as distributive considerations. Moreover, we need a proper understanding of distributive justice to fill with content corrective justice duties of repair. Finally, if we care about equality, private law rules should take this concern into account. If nothing else, I hope I've convinced you that contrary to Professor Posner's advice, when you drive back home tonight after the reception, you should not drive faster in a poor than in a wealthy neighborhood. Thank you very much.